Alabama State Senate passed a bill last night that'll virtually outlaw all abortions. The Senate voted 25-6 after the measure overwhelmingly passed in the House. State lawmakers say that the move is an effort to get the Supreme Court to reverse nationwide protections for abortion rights. CBS News correspondent Ilya Duncan has the latest from the state capitol in Montgomery.
House Bill 314 passes.
In a late-night vote, Alabama got one step closer to banning nearly all abortions. The bill makes performing an abortion a Class A felony. Doctors would face up to 99 years or life in prison. Unlike measures in other states, it would not punish women receiving abortions.
This bill, to me, appears to be about control.
Democratic State Senator Linda Coleman Madison is one of only 4 women in the 35-member Senate. All 27 Republicans are men.
You don't know what you don't know because you've never been pregnant. It's the choice of 2 people.
That's right.
But it seems like only one is being thrown under the bus here.
Motion to table.
Chaos erupted in the state Senate last week over an amendment that would have made abortions legal in rape and incest cases. The exception did not pass last night.
This is just a shame. This is a disgrace.
So far, 6 states have passed fetal heartbeat bills, banning abortions after 6 weeks before a woman may even know she's pregnant. Similar legislation has been introduced in at least 10 others. The Alabama bill's sponsor says it was designed to be contested and ultimately make its way to the now conservative-leaning Supreme Court.
We can't get a heartbeat bill until we get Roe versus Wade revisited and turned over.
But Democrats argue the Alabama bill will disproportionately endanger poor and minority women who already lack access to health care. Only half the state's 67 counties have an obstetrician or doctor who specializes in pregnancy. Mia Raven works with one of the 3 abortion clinics left in Alabama.
It affects more people than you know. The problem in the South is we just don't talk about it.
If the governor signs this bill into law, in theory it would take effect in 6 months. But groups like Planned Parenthood and the ACLU promise to challenge this ban, potentially bringing this debate back to the Supreme Court. Ilya Duncan, CBS News, Montgomery, Alabama.
Ilya Shapiro joins us now from Washington. He's the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. So, Ilya, we've heard those who say that these laws, the point of all this is really to ultimately go to the Supreme Court. Is this a threat to Roe v. Wade?
Well, it depends when exactly one of these cases gets to the Supreme Court. Already, there are a handful of cases pending before the Supreme Court. We're waiting on the court to decide whether to take up an Indiana law that bans abortion based on sex or race, admitting privileges law in Louisiana, another couple ones already. So we'll see if they have an appetite for any of this, whether they take any of these cases. They don't have to, because there is no split in the lower courts. That is, because of the law under Roe v. Wade, and even more, Planned Parenthood versus Casey, the 1992 case, all the lower courts rule the same way. So we'll see if they start chipping away at that standard with some of these cases that are already at the Supreme Court's doorstep.
You mentioned that there isn't that split at the lower court. So what would need to happen for it to actually make it up to the Supreme Court?
Well, you need 4 of the justices to vote to hear the case, to grant what's called a petition for a writ of certiorari. And are there those 4? I mean, are the most 4 conservatives, are they convinced that John Roberts, as the median vote now, the Chief Justice, that he would be willing to go in some direction? I think the conventional wisdom, which I agree with, is that Roberts is prepared to uphold certain kind of restrictions that were struck down when Anthony Kennedy was the swing vote, but he's not at this point ready to overturn the right to abortion altogether. But we'll see again. We'll see by the end of June whether they take up any of these currently pending cases.
Oh, yeah, I want to ask you, in an unrelated case Monday, Justice Breyer wrote that it's dangerous to overrule a decision only because 5 members of a later court come to agree with earlier dissenters on a difficult legal question. Is this a clear warning about respecting precedent? Do you think that's what Justice Breyer was sort of referencing on this one?
I'm sure that is what Justice Breyer was talking about. Several of the more liberal justices have been frustrated with a few of the overrulings of previous precedent in the last couple of years. But still, the Roberts Court has overruled fewer precedent at a lesser rate than any court in modern Supreme Court history. But it's, this idea of stare decisis, that is that the court should respect previous precedent, which is important because you don't want to change the law all of a sudden. But most people, they like the precedent that they like, and the precedent they don't like, they don't mind being overturned. We'll see if, again, Justice Breyer's warning, if John Roberts or anybody else listens to it.
Ilya Shapiro, thank you for joining us.
My pleasure.